Welcome to the Minnesota Court of Appeals Family Law Appellate Mediation webpage. My name is Emily Rice, and I am the Court Administrator at the Minnesota Court of Appeals. Thank you for taking a few minutes to learn about the Minnesota Court of Appeals Family Law Appellate Mediation program. The Court of Appeals established the Appellate Mediation program to provide you with a relatively low-cost and efficient means of resolving your family law appeal. During mediation, you and the other party in your case, along with your attorneys if you are represented, will work with one of our highly qualified and experienced mediators to develop a shared decision, your decision, on the issues in your appeal. Any settlement in mediation is voluntary. By participating in mediation, you do not give up your right to have the appeal decided by the Court of Appeals. This process is entirely separate from the Court of Appeals' normal decision-making process and is entirely confidential. Your discussions during mediation cannot be used in later court proceedings. Mediation also has some important advantages over an appeal. First, the Court of Appeals does not hear evidence, decide what witnesses are believable, or retry your case. In an appeal, the Court of Appeals reviews the family court referee's or district court judge's decision. That means that the party bringing the appeal must show that the referee or judge made an error. That is a substantial burden. It is not enough to argue that a particular witness was not credible or that certain evidence is more persuasive than other evidence. Instead, the party bringing the appeal must show that the district court's decision is against all the evidence presented at trial or against the applicable law. If the party that is bringing the appeal cannot do so, the appeal will not succeed. And because the burden of overturning a decision of a family court referee or district court judge on appeal is substantial, most appeals result in the Court of Appeals affirming the decision. Mediation, on the other hand, is a process in which a mediator will talk with the parties to identify their needs and priorities and to craft a resolution that is agreeable to both of them and in the best interests of the children. In other words, mediation gives the parties control of the outcome of the case. Second, an appeal takes a considerable amount of time. From the time the appeal is filed in the Court of Appeals until the time that you have a decision, it will probably be almost a year. The case may remain unresolved even longer if one party seeks review of a Court of Appeals decision by the Supreme Court, or if this court sends all or part of the case back to the trial court. Mediation offers a shorter and more definite timeline. While some time is required to refer an appeal for mediation and select a mediator, the actual time for mediation may be a matter of days, and a full settlement in mediation can end the case entirely. Third, appeals involve the financial burden of having transcripts prepared, filing briefs and other documents, and for many, substantial attorney fees. Because the timeline for mediation is shorter and it is the parties that define the process, many of these costs can be avoided or reduced in mediation. Finally, while mediation is generally mandatory, it is not for everyone. For example, if your relationship involves a history of domestic abuse, mediation may not be appropriate for you. Please note this history or other special circumstances on the confidential information form. The coordinator of the Appellate Mediation Program is Maggie Hawkins, who can be reached by telephone at the Minnesota Judicial Center. She will be contacting you, or if you are represented, your attorney, so that a mediator can be selected and the mediation of your case can be scheduled. She is responsible for coordinating this mediation process and will be available to answer any questions you may have. Also, if you follow the links on this page, you may review our other online resources, including frequently asked questions, our mediation policies and procedures, and the confidential forms for getting started with mediation. Thank you for allowing me to describe our mediation program. We expect that this program will provide you with a good opportunity to resolve the issues in your appeal successfully.